started.
Hang on one second. Okay, thanks for joining us for another noontime CLE. Today we are lucky enough to have Paul Franciscowicz from Peter Latz & Associates. He's a probate practitioner, does a lot of fine GAL work for CVLS on a pro bono basis. You can find him regularly on the 18th floor. I've heard him speak at other events. He's a pleasure to have, a pleasure to listen to, and he knows his stuff. Just briefly, keep your calendars free on the 13th of September. That's Race Judicata. I'd love to have you guys at the lakefront for the 5K and the beer and donuts afterwards. Make sure that you either click on the link to request MCLE credit on the web page, or see me if you're in-house for certificates afterwards. And also, if you're viewing online, there are attachments. If you scroll to the bottom of the page, there's Paul's materials. So without anything further, Paul Franciscowicz.
Thank you. Good afternoon, I'm Paul Franciscowicz, and this is Lisa Hendricks. I have been a guardian ad litem in Cook County for approximately, I think, 11 years. I currently practice almost solely in probate, and I have been appointed as guardian ad litem for disabled adults, counsel for disabled adults, counsel for children in probate for guardianship matters, and guardian ad litem for children in probate matters. I've also been a guardian ad litem in chancery for children and unborn children in trust contests. And I've also, my first job was representing abused and neglected kids as their guardian ad litem and attorney at the Public Guardian's Office. What I wanted to talk about today is the more difficult cases that come from guardianship and the role of the guardian ad litem and things that you can look to kind of assist yourself in your practice. It's not just limited to guardian ad litems, so these are the same things that you can do in either representing interested parties in guardianship cases, respondents, or guardians themselves. So there'll be a lot of crossover. I did want to just, at the very outset, just give you a couple of the enabling statutes for why there's authority for having a guardian ad litem and what their role is statutorily. First off is 755 ILCS 5/11A-10. That is the statute that requires the mandatory appointment of a guardian ad litem in a probate matter unless the court deems that it can make a reasoned decision without the appointment of a guardian ad litem. So that is the statute for which the guardian ad litem would be appointed pre-adjudication and begin their involvement in the case. The exception, when is it not reasonably necessary to have a guardian ad litem at the beginning of the case, is generally just limited to cases in which a respondent may appear in court and has a lifelong disability from birth. So someone who suffers from some type of developmental disability, some type of autism, mental retardation, something in which a guardian ad litem would not necessarily be required and that the court can do its own investigation at that hearing and not require the appointment. Otherwise, that is a requirement. There are several other statutes, though, where a guardian ad litem can be appointed. Routinely, a guardian ad litem, and it's not by statute, but by practice, would be discharged at some point around the inventory stage. So after a guardian's appointed, say it's a guardian of the person. The role of the guardian ad litem might be terminated on the date that the guardian's appointed, and there is no further court date for a guardian of the person. There's only an annual report to be filed. Guardian ad litem's role at that point would be discharged. In an estate matter, the guardian ad litem may stay on to an extra date, which would be the inventory date, which would be required to be filed within 60 days of the guardianship being appointed. And at that point, there is, by practice, a discharge of the guardian ad litem. In other cases, a court might feel that there is too much animosity or there's still outstanding in case litigation, may keep the guardian ad litem on indefinitely. Okay, there's nothing specifically in the statute that requires the discharge. Now, if we have a guardian ad litem that's discharged, There are circumstances in which a court would reappoint, and this would be the role of the guardian ad litem in some of the more difficult matters. And again, they're all by statute when a guardian ad litem would be reappointed. Specifically, there is section 755 ILCS 5/11A-20B, which references whether or not there is going to be a restoration of a guardianship. So the circumstances which you would have a reappointment of a guardian ad litem or a new guardian ad litem appointed, because there's no requirement that the court use the initial guardian ad litem, would be that there's some information provided to the court that a ward or someone on behalf of a ward or a family member or anyone has notified the court that this person who's under guardianship either doesn't want to have a guardian anymore, would like the guardianship transferred to a different person, or would like to have some issue with respect to their guardianship amended or changed. And under that circumstance, a court can appoint a guardian ad litem to investigate that. Okay? And that would be the first process. The guardian ad litem's responsibility in that case is to go out and meet with the ward and determine whether or not whatever letter or communication has come into the court, and that can be ex parte, that comes to the court, follow up on that and provide some information to the court on what they think should happen. So I'll give you an example. A person writes a long letter, it's 62 pages long, and says that the government is after them, they do not want a guardian, and that they think that the whole process is corrupt. They mail that out to the judge. Okay? Upon receipt, because that person has indicated that they do not want a guardian, the court will review this document and then appoint a guardian ad litem to go meet with this person to determine whether or not it's appropriate. Now, as the guardian ad litem, it would be your responsibility, specifically under this statute, to determine how this matter should proceed. So, for example, you would go out and you'd interview the respondent individually, find out from interviewing them whether or not you can determine from an interview that their condition has changed such that they may not be in need of guardianship. Has there been some improvement? Has there been some change of circumstance? In our case, we can indicate that the facts are generally the same. In the interview, they might indicate that they don't trust their uncle, who's their guardian, and they've asked for somebody else to serve. Okay. Maybe they've also indicated that they want to contest the guardianship and they no longer want a guardian. So you would take that information, you prepare a report with your recommendations, and the matter would be back before the court, in which case the court could appoint an attorney to represent the respondent. Now, the way that works is that you have to be careful with what respect to your role is, because there's two separate statutes. The one is 11A10A, which is the guardian ad litem appointment, and then which is almost the very next section, which is the 11A10B, which is the appointment of attorney. And the role of the two parties are very, while they may at some points be the same, can be radically different. The best way to think about it is that if you had your child asked you for like a piece of cake, if you're their guardian ad litem, you would say, well, why don't you have one piece? If your child asked for the whole cake, as their attorney, you would say, okay, we're going to advocate for you to get the whole cake. So you may or may not have the same interests. So your appointment under the restoration section as guardian ad litem is to determine whether or not that this person's in need of guardianship. So you have to provide that information to the court. Now, if you take a position on guardianship, you'll be prohibited and should be prohibited from then representing this person, okay? Because you wouldn't want to take a position for meeting our friend who says that the government is involved in his conspiracy versus guardianship, and then make all of these statements about how these are unfounded, they're paranoid delusions, that the person's condition hasn't changed. They recommend, they want to challenge their guardianship, and that you think that you'd be a great attorney to represent them, okay? One, you may have the problem that in a restoration hearing, you as guardian ad litem would be called as a witness, because you went ahead and interviewed this person pursuant to the guardian ad litem statute. You took down all your notes in your discussion, and then you had an opinion. So it would be impossible for you to assume the role of an attorney when you are a witness and your position is actually contrary to the wishes of the ward. Okay. So in our circumstance, we go out, we see the person, we think that they still need a guardian, we report that back to the court, but we also let the court know that the person does not want a guardian and wants to have that vacated. And the court will appoint an attorney. The attorney then will follow the procedures for a restoration hearing, and your role is limited to the recommendations. Okay, so that's something where you could be appointed as a guardian ad litem well after the appointment of a guardian is installed, and again, unrelated to the initial appointment. The other enabling statute is the Sterilization Statute, which is 755/11A-17.1, which is essentially the statute which requires the appointment of a guardian ad litem if there's a petition for sterilization of a ward. It's a very lengthy statute that follows generally the case law of KEJ, which previously set out standards on how you could perform a sterilization on a ward. If you're appointed in this matter, there are very specific questions that are required to be asked of the ward, and those have to be taken down and then included in your report. And those are by statute and required. So here's another circumstance where we have a guardianship, the guardianship's over, our guardian ad litem's been discharged, and again, someone is being brought in for a separate matter that was unrelated to the existing guardianship. You could be, although not required, pursuant to DW. DW is a statute that allows for the termination of a pregnancy. The site on that is 134 ILAP 3rd 788. You could be appointed a guardian ad litem to determine the appropriateness of termination of a pregnancy. I have been appointed actually on 3 cases in which that's occurred. So it is more common than you might think. Other circumstances where it's a guardian of a person role, where you might get appointed again, would be possibly some medical decision. Generally under the Healthcare Surrogate Act, if the person lacks decisional capacity, and that's attested to by physicians, a surrogate decision maker listed under statute can make medical decisions. And if you're a guardian, the person's right to object is severely limited, such that it can be made even over the objection of a ward. However, what I have seen in practice is that hospitals and doctors will not want to treat a patient who's objecting, even if the guardian is consenting, if it's an outstanding issue and would require a court order. So I've had circumstances specifically where someone had filed a petition that they wanted to withdraw food and water for a ward. And they filed a petition for that. Under the statute, the guardian is authorized under healthcare surrogate to go ahead and execute. Does not need a court order, but they came to court and they requested it. So the court appointed me as guardian ad litem. I went out and met with the respondent, who was very, very ill and was barely able to talk. But one of the things who he had mentioned to me while I was interviewing this person was that they really wanted water because they were thirsty. And this person was initially put on withdrawal of food and water. So there could be circumstances where you're appointed and you'd have to, present recommendations to the court, even though there's not a specific statute for appointment of a guardian ad litem, like that situation. A placement of a ward in a residential placement under 755 ILCS 511A-14.1. All but the state and public guardian are required, although even those 2 organizations seek court orders, require a court order before you residentially place someone. So if you're going to put somebody in a nursing home and they're a ward, you got to get a court order. You may have a judge appoint a guardian ad litem to meet with the ward to determine what their wishes are. Okay. Again, that's not by statute, but that's by practice where the court might do so. Now, I brought up some circumstances where there's these personal decisions and we're having a guardian ad litem appointed, but there's not really necessarily a statute for that. And the question would be, well, why are we looking to do that? Because guardianship is a little bit different than other types of litigation. There's not necessarily 2 parties of interest here. Once a guardian's appointed, a respondent now becoming a ward lacks the decisional capacity and the rights under person and estate to make almost all of their decisions. Okay? By practice, most of these people are either in residential facilities, nursing homes, or under, and this is not a bad thing, but under the control of their guardians and would not be able to make it to court. So in a lot of circumstances, what you have is you have a petition filed by a guardian asking for some type of relief. and there's no counter petition. There is no other party to say we object. There is no other party to present another view. The ward themselves may not receive notice on these pleadings anymore, and so he may be unaware that there's even court occurring. So you'll have the judges appoint a guardian ad litem for certain circumstances like this that don't necessarily require it, because there is this inequity within the probate system in that it is essentially a one-party system after the appointment of a guardian. Again, so these will be certain circumstances that you will be appointed to review certain decisions for which there not necessarily is an enabling statute. Now, there is a catch-all to everything on why the court has the right to appoint a guardian ad litem, and I've heard many, many, many times, sometimes justified, sometimes not. Why do I have a guardian ad litem on my case? Why are they still on the file? Why did the court appoint them? And there's a specific case on point, and it's called the estate of Michalak, spelled M-I-C-H-A-L-A-K. And the statute for that is 404 Illinois Act 3rd 75. And just like I said, this was a suit in a guardianship case regarding some missing funds, and the court appointed a guardian ad litem because it was taking forever for accountings to get done. And one of the arguments that the people who were the guardians in this case made is, why do I have a guardian ad litem? Where does the court get authority to go ahead and appoint somebody? And the court actually cited another statute here, which is our catch-all statute, which is 755 ILCS 5/11A-18-C, which says, the guardian of the estate of a ward shall appear for and represent the ward in all legal proceedings, unless another person is appointed for that purpose as guardian or next friend. This does not impair the power of any court to appoint a guardian ad litem or next of friend to defend the interests of the ward in that court, or to appoint or allow any person as the next of friend of the ward to commence, prosecute, or defend any proceeding in his behalf. That's essentially the catch-all, where the court can appoint a guardian ad litem for virtually anything that it deems appropriate within the bounds of a guardianship case. So, you know, if the question is, why do I have a guardian ad litem? Because the court wants one, and they have authority under this statute and under the Michalak case, which is broad enough for any issue that they deem it useful for their purposes to have someone on there. So, being a guardian ad litem doesn't always just necessarily talk about the appointment issue. It's not just going out to see the ward doesn't object, the ward seems fine in the nursing home, case closed. A guardian ad litem can be anything that the court deems appropriate, any litigation, any motion, anything that you could think of. And under any of those circumstances, you have to be prepared for cases, motions, and things that are not going to be the run-of-the-mill regular probate matters. They can be anything. And so those type of appointments are going to be the most challenging. Now, you can also be appointed with respect to estate matters. The Michalak case specifically was the purpose of getting a guardian involved because there was the lack of accountants. And the majority of post-guardianship appointments are going to come up from the estate administration. And the circumstances that you generally will have, and I think that I've had this happen at least 3 dozen times, is that the case is up, it's been up 5 times, there is nobody appearing, the lawyer is not showing up to court anymore because he says he's not getting paid, the client hasn't done an accounting, and the court wants to know where its accounting is and why is it so late. And what the court will do is the court will then appoint a guardian ad litem, whose responsibility it is, to go out and investigate what's going on with this accounting. What's the issue here? So you'll find that that will be a lot of the estate administration review and what your purpose is. And you have actually quite a few tools as a guardian ad litem on how you want to handle that. Okay. First thing that you can do is you'll find out from a review of the file how far in arrears people are. Okay. And, you know, has there ever been any inventory? Has there ever been any accounting? And obviously the first thing that you want to do is you want to get the guardian to complete as much of this work as they can on their own and review what work they have. So the first thing that you would want to do is you'd want to have orders compelling their appearance and dates certain for accountings to be due. So you don't want necessarily this matter is continued for status. What you want is you want an order directing that the guardian is to complete the first and current account by May 1st, 2012. You want firm dates to establish a timeline when things need to be done. And that's basically for what we're going to talk about for the majority of this, which is the removal process. You want to have specific orders that the guardian is required to follow. Now, for the most part, getting some specific orders in on the guardian is going to jog them to appear in court, is going to get the lawyer in court because you can also enter orders that the counsel is required to appear on the next date, and to get them in there and provide some explanation for what's going on in the state and why it's been 2 years and there's no accounting done. Okay. Once you get them there, then that begins the process. But again, just getting a guardian and his attorney in court doesn't necessarily mean that you're going to have the accounting complete and investigate what's been going on in this estate. So the next component of that, after you've begun the process of ordering them to do it, is that you can do one of two things, or you can do them together. One is a suggestion of bringing in the bonding company. Okay, most likely, or you hopeful, that the guardian, upon their appointment, executed a bond, and hopefully it's enough to cover the value of the estate. And you can notify the bonding company to appear, and since they are jointly and severally liable for any potential shortfall, they like to be involved at the earliest stage possible to complete the process of the accounting to minimize their own exposure. So you can have a separate order requiring the bonding company to appear. If the guardian himself is not getting the accounting done, you can have the bonding company ordered to complete the accounting as well, because again, they are jointly and severally liable under the bond for liability under administration of the estate. The other process that you can do, and sometimes this is actually the quickest and the easiest, is that you can do a review of the records and you can prepare the accounting and you can investigate what had happened in the estate. So if you do have some background in accounting and being able to review financial records, this might be your quickest route to actually getting the case resolved. Again, if you don't know how to do this, then again, this might not necessarily be the case that you want to handle, because ultimately, no matter what is presented, you're going to have to review it for its accuracy. So you want to know how to do an accounting, how to review financial records, how to review the appropriateness. I'll give you two stories that are absolutely true. One is mine, one is a friend of mine, on how they handled. I was a guardian at Litem in a case in which a woman had the same situation. She had gone through 3 lawyers. She couldn't finish the accounting. She couldn't finish the accounting. No matter what she could do, it just wasn't getting done. So I said, look, just drop off all the records at my office. I'll go through them. I'll prepare your accounting for you. You'll review it. If it's accurate, you can sign it. We'll get this thing done. So she dropped off the records, and they were fairly complete, enough so that I could finish the accounting. However, she had turned over photocopies, not the actual bank records. And one of the things that we noticed in reviewing the records is that there were 2 checks for check number 264. There were 2. One of them was written to cash, and the other was written to a caregiver. And if you took the 2 checks and put them over each other, you could see that part of the line was missing. And then what she obviously had done is that on some of the checks, she had whited out who the vendor was, written in a new person, photocopied it, and then put the fake check with the documents. But what she failed to do is she forgot to pull the original check. So by doing that, we were able to find just the one check, which was a mistake that she put in there. And so I went ahead and I subpoenaed all of the records and found out that there were 18 checks that had been written out to cash. After we were able to determine that, I was able to complete the accounting, which showed that there was the shortfall. And we went to trial because she alleged that it was actually just a big misunderstanding, that although it was written to the caregiver and that she fraudulently filled it out, that she really did use the money for the war. So what we were able to determine is that some of the ATM transactions, after we looked at them, we looked at the location, were close to the Indiana border where there's the casino. And so the next argument that she came up with is that she had brought the ward to the casino, because the ward enjoyed going there and dropping $1,000 at a time at the blackjack tables and playing with the machines and things like that. Well, as guardian at Litem, I had already gone out and met the woman. So I wanted to, before I even heard this story, I had gone out and seen her in the nursing home. Unfortunately, she was in very bad shape and actually had been in a wheelchair, and she had something that was called a lap restraint. And it's essentially like a table that goes over so that you don't fall out of the chair. And then she spent the majority of the day head first down on the mat because she couldn't, so that she couldn't move around. She couldn't ambulate by herself. She couldn't talk. That's what she was doing during the day. She also had COPD, and this was back when some of the casinos were still smoking. And so we went to trial on this because she was assuring us that, in fact, that money had gone, every penny had been used for her care. The accounting was approved. There was found to be a shortfall. The expenditures were not approved. It was assessed against the guardian, and then suit on bond, which I'll give you the statute. Suit on bond is suit on bond is 755 ILCS 5/12-15, which is after you get judgment, you then seek payment from the bonding company. And we had the bonding company was required to repay the estate for the stolen money by the casino lady, as well as the attorney's fees that were lodged in trying to deal with the guardianship. Okay. So again, one time, even if you get an accounting, okay, and it seems to be okay, that's not necessarily determinative that everything is going to be fine. Now, there's not every single accounting are you going to do this type of inspection. It's probably impossible. There might not be any reason to have, but there's things that you need to look out for when you're reviewing these documents to see if there's a problem. There's just things that you need to look out for. Another case which was equally as bad, which was handled by another attorney that I know, it was a minor's estate, and what the guardian had done is had doctored the bank statements to show a current balance, even though they had gone to the bank and cleaned out all the accounts. So they gave their attorney bank records, but they were doctored to show that the current balance was still the funds that were in the estate, even though the estate was at zero. Okay, so people are tricky. So as a guardian ad litem, you got to be one step ahead. You got to make sure that you're able to take a look at these things and figure out whether or not there's a problem, a potential problem. Things that you want to do when you review the accounting. Some judges require budgets. It's not by statute, but it's good for administration because it gives you an idea of what you're supposed to spend money on, what you're not supposed to spend money on. As a guardian ad litem, you should be checking the expenditures versus the budget. Do they match? Do they make sense? Okay. There's cash to Olga, who's taking care of the ward. Okay. Is there any withholding or reporting? So you have to check. Is there any taxes being taken out? Are they paying unemployment? Because here's what happens. Olga strains her back. She sues the estate. Olga gets fired. She fires for unemployment. Okay? I understand that, people, well, we've always known Olga, and Olga's going to be good to us until Olga sues the estate. As a guardian ad litem, it's your responsibility to go through these expenditures and see, what are we doing about taxes? Well, we decide that we're not going to withhold taxes, so it ends up that the federal government wants to know why you didn't pay into Social Security for this employee of the estate. And then now the estate has additional liability because that hasn't been done. So again, these are things that the guardian ad litem needs to review. There's things that I have seen as, not necessarily as a guardian ad litem, but on accountings, which can cause concern that you should just be aware of. For example, if there's real estate, you should check during the year. Was there a payment made for insurance on the house? Sometimes there's not. Okay, that would be a breach of the guardian's duty not to adequately insure the property. Check the real estate taxes on the accounting. Has there been a payment for during the calendar year of 2 payments? Sometimes there's not, in which the guardian hasn't made the payments. Or sometimes there's 3 or 4 payments, which shows that were the payments not made in previous years. Those are things that you need to look out for. Here's I don't have the name of the case with me, but this also happened in a matter that I had handled as well, is that a corporate fiduciary had left a large amount of cash in a non-interest-bearing account. And it happened to be an account held by the corporate fiduciary. It was their own bank account. So they had approximately $300,000 in a bank account held in their name, and it offered no interest for the ward. So they charged roughly a almost 2% rate for managing the money that was in a zero amount account, that they themselves were then able to lend out and themselves because it was within their own organization. Okay, there is case law and also a statute, in fact, that says that uninvested money is subject to, I think it's 90-day T-bill rate for surcharge. So you'll have, if you look at an estate, you want to see, is it even invested? Okay, we have a lot of guardians who are unsophisticated guardians. They may leave everything in a checking account, and it's $100,000. Now, does that mean that they have to be surcharged? They could be. Could they be removed? Possibly. Or do they need to be instructed in their counsel that, move this money into something that's going to generate some income for the ward? Okay, those are things that you, as the guardian ad litem, need to look out for. You also want to look out for home repairs. Are there things that are like enormous expenses that hadn't been sent out for court permission? Okay, some things will be an emergency and they need to be done. But there's a new roof on the house. Well, how did this happen? Well, my uncle does roofs, so he did the roof. No competitive bidding. Okay. Your job as guardian ad litem in reviewing these accountings is to look underneath all of the expenditures. Was this appropriate? Does it make sense? Okay. And you can approach them in a couple different ways after they're filed. One, you could do a report to the guardian, a report of guardian ad litem that outlines your concerns with the respective transactions. You can do objections to the account, or you can file petitions for removal for the guardian for cause for the transactions that they conducted as guardian. Again, those are going to be a decision that you're going to make on a case-by-case basis. With almost, except for maybe corporate fiduciaries, you could probably go through maybe half accountings that are filed and find some type of error which would be a breach of fiduciary duty. The question would be is whether or not that reaches the level such that you would want to proceed on a removal petition. But it's your job as guardian ad litem to alert the court to those facts and to make sure that that issue is brought out to the court so that they're aware of it and it can be addressed and it can be prevented from happening in the future. A guardian ad litem can also be appointed in a citation proceeding. And this one's actually a little different. It's not a guardian ad litem. What the statute says is that, and it is, here it is. It is 755 ILCS 5/16-1 subsection C. And this refers to a citation statute, which we're going to talk about for the majority of today's talk. And citations are generally filed by the estate against other parties to collect assets that are missing or discover assets that might be missing, to quiet title, to collect bank accounts for some reason that won't cooperate with letters of office. The citation action can be used to discover books, papers that might be held by a third party. They can be used to recover assets that someone stole from the ward. They have a variety of uses. But they can also be used actually against the representative themselves, and that's what we reference subsection C, which says if the representative is the respondent. So if we're actually using the citation against the person who is the guardian, the court may appoint a special administrator to represent the estate. So a special administrator is a person who has some authority, and in this case they have the authority to prosecute or even defend an appeal in this matter, depending on where the case goes, to take a look at the action and proceed against the actual guardian for some type of misconduct. Now, although the statute allows the court to appoint a special administrator, I have seen in practice the majority of the time that the court would direct the guardian ad litem or some other third party who's being involved in the case to file that citation action against the guardian. Okay, but according to statute, a special administrator could be appointed. And then there's a separate special administrator statute, which enables them to act in both decedent and guardianship cases. Okay. Now we kind of talked about, in general, what your role is in kind of trying to ferret out post-adjudication. Some of the more difficult issues, like what are we going to do about, our ward who may have to go to a nursing home, or somebody, like the case that I talked to you about, they wanted to withdraw food and water from a person who wanted water. we have many options from as little as filing a guardian ad litem's report, which just expresses our concerns and objections, and the court can rule on that, to asking the court to deny the requested relief that the party is seeking, to something which reaches the level which is the removal process, when we believe that the guardian has committed a breach of such a nature that they no longer can serve in a fiduciary capacity as a person in a state. And this is essentially where you take on the role of seeking to go ahead and remove the guardian. These will be your most difficult cases, because these are the cases in which you've made the determination that essentially there is really no ability to work with this guardian anymore, and that whatever misconduct they have is so serious they should not have anything to do with administering either the estate or making personal decisions. Okay, so you may have things like a guardian goes on vacation and doesn't tell the nursing home that they're gone and leaves no contact information for the ward, so that there'll be somebody there to consent in case something happens. Person falls, they got to go to the hospital. There's nobody there to deal with them. Okay, or a guardian who moves a ward from one situation, maybe from an assisted living to a nursing home, and doesn't respond to the court, and the ward doesn't want to go and object. Maybe you have a guardian who does some financial transactions which aren't appropriate, maybe lends themselves money because they're out of a job, or pays them their own fees without a court order, and they'll take care of it at some other point. In those circumstances where you feel like it's reached the level such that there isn't an order that can be entered that ameliorates the situation, this guardian has a breach of trust. Under those circumstances, what we're going to do, and this is what the handouts are for essentially, is for a petition for removal. And essentially the petition for removal is governed by statute 755 ILCS 5/23-2. And this references representative, which means guardian of the person, guardian of the estate, guardian of a minor of the person, guardian of a minor of the estate, executor, administrator, administrator to collect, even a special administrator. There's some type of misconduct, so a representative would need to be removed. Okay? Who can this be filed by? Essentially two different people. One is any interested person, and that's by statute in the definition section of the Probate Act, and it is a long list, longer than my arm, of virtually anybody who could be involved in a case having any type of potential interest, or by the court's own motion. You will find, if you're a guardian ad litem, that generally this is going to be directed by the court, because the court says, I'm appointing you as guardian ad litem, I'm directing that you file a motion to remove this guardian because they haven't cooperated with the orders that I've given. So essentially, it's the court has directed that the petition for removal be issued. Okay, those are the parties who can go ahead and file a petition for removal. For purposes of procedural practice, in general, the first document that is filed is a petition to issue citation for removal. That's your petition in which you lay the grounds for why a citation should be issued, excuse me, against the guardian, and why the guardian should be removed. That doesn't necessarily require notice to the guardian. That is either granted or not granted by the court. If it's granted, then follows the actual citation.
We're back. Thank you, viewers, for your patience. We had a technical difficulty. We are back up. We've paused for you, and now Paul will continue with the citation to remove issue.
Okay, so what we just kind of ended up on is that you're going to have 10 days service prior to your court date. So make sure you give yourself enough leeway so that you can get service. I would also generally recommend that at the time that you get permission to issue this, that you go ahead and get permission to do a special process server. The sheriff's office may not be on your schedule, and you have a very tight timeline between the date that you issue and the 10 days. So it's not just you get served with it and then you have 30 days to respond. It's always going to be 10 days before the court date. So it's a little bit of an issue, so you want to make sure you get that. You can obviate that by sometimes you get lucky. Sometimes the respondent or the citation respondent shows up to court, and then they'll take it. And then you make sure that you write in the order that they've acknowledged and received the citation and waive notice. And you want to make sure that you have that there so that there's no jurisdictional issue on the removal. There is You know, some of our cases, you know, the whole point of why you got appointed is because the guardian's not appearing. So there might be cases where the guardian is gone and cannot be found. There is a specific procedure in the statute that requires you to go to the clerk's office, and then it's a notification that's sent by the clerk after you issue an affidavit that under reasonable inquiry they cannot be found. And then the clerk's office will do a mailing to last known addresses, and that will then give you your service if you can't actually get the person served, which is probably a good indication that a person's going to get removed if they can't be found. As a basis for removal, the statute has a bunch of grounds. We'll talk about them really quickly and some examples of them. A representative is acting under letters of office secured under false pretenses. This is the Derek Thomas case, which was a guardian who was convicted of a felony and settled out a case that was for pennies on the dollar for his ward, who was in a terrible car accident. The settlement was revoked. He was removed as guardian. A new guardian was appointed, and ultimately he had a multi-million-dollar settlement. This is a Cook County case, and that is a basis for removal. Lying about your felony status. Representatives have been adjudicated as a person who's subject to involuntary admission under the Mental Health Code. So your guardian ends up getting locked up, and they go in for a commitment hearing. Again, the purpose of that is one of the elements for being a guardian is of that you've not been adjudicated a disabled person. So here we have an issue where post-guardianship, you're having some mental health issues that might preclude you from serving. Representative's been convicted of a felony, so that would be subsequent. So it ends up that your guardian is convicted for bank fraud and probably stealing money from the ward. Okay, that would be a basis for removal. Representative wastes or mismanages the estate. So during our review of the accounting, we see that money is uninvested. We see that money is loaned to family members. Money is spent on personal items. Fees are taken in an exorbitant amount without court permission. Many possible examples. That's a basis of removal. Representative conducts herself in a way which endangers any co-representative or the surety on the representative's bond. That's the same as D. It just means that the bonding company would be liable for your misconduct. But if A is or D is true, E is true as well. Okay. Representative fails to give sufficient bond security, counter security, or a new bond after being ordered to do so. Well, this is kind of a hard one because in general, it would be, I think, somewhat rare to be in court, have the court order you to issue a new bond, and then fail to do it because it can be done while you're in court. I think you probably would want to maybe use this to say that they underbonded the estate, knowing that the estate was $500,000, only got a $100,000 bond, put the estate at risk for $400,000, knowing that there wasn't sufficient bond. I have not seen any case where they refused to sign the bond document. But you might have circumstances where the bonding company might not be willing to do a new additional bond, in which case then the person can't serve as a matter of law because they can't produce the appropriate surety. Representative fails to file inventory accounting after ordered to do so. This is why I mentioned before that you want firm timelines for your guardians. You don't just want things to be set for status. You want things for presentation and filing of documents, because that gives you a firm timeline later on when you can point to and say, this has been violated. I have, he had a guardian removed for, in the last year for failing to do an inventory. I mean, that's within 60 days of being appointed, he had to be removed. And it was continued 4 times for him to do it, and finally I filed a motion for removal and it was granted. Okay? He was never going to do it. It just, you know, he had a lot of issues and he just wasn't going to get around to it. That's a basis for removal. We did cite here a case. I think this case only had a 30-day lag between the accountings. So, I mean, you got to be somewhat reasonable as, you know, either as a guardian ad litem or maybe just another family member who wants to get rid of the guardian. There is a reasonable time between doing accountings. Okay, and generally the court would set a 60-day date after the close of the last account for you to present the next one, because you don't get all the bank records until, you know, the month after the accountings ends. So then you prepare the accounting, and that takes a little bit of time. But if it takes a continuance or two, that in of itself is definitely not the basis for removal. It's the guardian's inability or unwillingness to do so. I had a matter in which a guardian was ordered to do an accounting for a year, and it was obvious that it was the attorney who just didn't know how to do it. He provided me an accounting. I ultimately ended up doing the accounting myself from scratch. There was no shortfall, but it was beyond the work of the guardian. I did not do a removal petition. In the alternative, I requested that she resign. The Resignation Statute 755 ILCS 5/23-1. A guardian may resign or a representative may resign at any time, even without notice. So what I asked the guardian to do is that, she was unable to get this project done. It had taken over a year. Her lawyer wasn't able to do it. She was stressed out because her family had been filing motions on her, and I just asked her to resign. She resigned. So there was no removal petition. And then we had a corporate fiduciary manage the money, and that worked out fine. Okay. So the failing to file an inventory has to have something a little bit more than just a couple continuances. Representative conceals himself, herself, so process or notice cannot be served upon him. This is the circumstance which I just talked about, where we can't find the guardian and they're not around. This is not always a basis for, it is a basis for removal, but may not in practice be something that you'll use. There are many, many cases where people do pro se guardianships of the person, and then they move. And they stop sending their annual report on the ward, which is required to be mailed to the judges. I've seen cases where somebody stopped mailing it for 14 years. Guardian died, nobody knew about it for 5 years. I've had cases where people moved out of state. All kinds of things can happen. And in and of themselves, although it is a violation because nobody knows where they are, a lot of times for these pro se guardianships of the person, there's not any intent to defraud the court, to avoid court information. At some points, they weren't even handed the handbook, which they now have out to hand out to the guardians to explain what their responsibilities are. A lot of times, people are just unsophisticated, and they're taking care of a disabled brother, and they're doing a good job. They just don't send in the report. In those circumstances, it would probably be, appropriate for you to go out, meet the ward, make sure everything's okay, and then, go ahead and have them file their annual report, and then from there on, they can just, get back on track and do it again, as opposed to doing a straight removal. I'll explain. I had a circumstance which didn't require a removal, but it was a very similar circumstance where a court hadn't gotten any information on this ward in a long time. And she was extremely disabled, and the report said she couldn't communicate, she couldn't walk, she had brain damage and cerebral palsy, and she was not able to move or to feed herself at all. The guardian was her stepfather, and there was no contact from the court for years, and the judge just asked as a favor if I could look into it. Through a lot of different kinds of investigation, I was able to locate where she should have been living, and I ended up finding out that her stepdad had died, and that she had been living in her senior housing with a neighbor who had been watching her and just didn't know what to do. And she'd been there for like almost a year after the father had passed away. And in that circumstance, again, it's not a removal petition or anything like that, but what we did for her is we were able to, the neighbor wasn't able to actually take on the guardianship long-term. This girl needed such a level of care. So we were able to get the state guardianship involved, and they located a long-term placement for her, and then we maintained the relationship with the neighbor so they were allowed to visit. Okay? So those would be circumstances where maybe the court doesn't have notification about the file, might appoint you, and you end up finding out that we need brand new successor guardians here. Okay? Another possible basis for a removal: representative becomes incapable or unsuitable for the discharge of representative's duties. Could be a lot of different things. I kind of think off the cuff, drug, alcohol abuse, something like that. Maybe they have a terrible bankruptcy and they blow all their money. Something that says that maybe they shouldn't be managing this estate. Maybe they themselves have been adjudicated a disabled person. Okay. There's other good cause to remove the representative. There's your catch-all. That's anything you could come up with. So that'll be virtually anything else that I haven't thought of or you haven't thought of that could be a potential basis. Now, under here, we cited a case because this is a weird kind of case that doesn't really fit in the removal statute, because removal generally is referencing malfeasance. The guardian's done something wrong. There's this one case, and we cited it here for you. which is Debevic. Debevic is, I think, a 5th District case. What happened in that is kind of interesting because this girl, I think, was under guardianship with the public guardian in that county. They did nothing wrong. They took care of her. They did a good job. A family member showed up and said they wanted to be guardian. The public guardian didn't want to resign for whatever reason, so there was a removal petition and it was granted. But there was no cause to remove the public guardian. The court found other cause, good cause shown was that the relationship between the family member and the ward was so positive that even though nothing bad happened, it would be good to remove this guardian and appoint the family member because they would take care of the needs of the ward. Okay? I have never seen this successful in any other case, but it exists, so you should be aware of it. Okay? Generally, removals are for malfeasance. Same case, this county, under those circumstances, what you would be looking for as opposed to a removal petition is talking to the guardian about a resignation. If there is that wonderful relationship and there's no problem, you will most likely have your state or public guardian want to resign and have a family member take over your responsibilities. So again, that's something that you want to take a look at. I've given you a bunch of cases which are referencing more decedent's estate type things because in general, those are the type of misconduct that are published. But again, any one of those is the same thing that a guardian can do in a basis for removal. Okay. If you go forward on your citation because your guardian comes in and objects and says, no way, I want to keep the case, I'm not being removed, they can respond in writing to your pleading. You have to have a hearing, and you're required to prove the removal for cause by a preponderance of the evidence. The court will have a determination then whether or not the guardian should be removed. What I would suggest that you do is, at the same time you're proceeding on this removal petition, which may actually take quite a long time. You don't know. This could take one court date. It could take 6 months. It could even be a year, depending on how complex the litigation is and what the malfeasance is that you might, in the interim, feel uncomfortable that this person continues as being guardian for the next year while you litigate. Under those circumstances, what you're going to do, and I've included a copy in the materials, is file a petition for temporary guardianship, seek to suspend the powers of the current guardian, and assign those rights out to a neutral third party while you go through the litigation. So that way, whatever issue you've raised to the court can be preserved, and that during the interim of the litigation, there is someone there to monitor the situation and have somebody in to make sure that the ward is safe and the money is appropriately managed. And then you can take, whatever time that it takes to object. Because again, you could ask for a hearing, you could ask for depositions, discovery, and this could take a long time. And in the interim, you could have a guardian stealing all the money. I had one circumstance where I had a guardian who filed an accounting, and it appeared that there was no money missing, but after, again, investigating a little bit more, I saw that there was $1 million missing. And he was a very well-known person and had taken money from his mother's estate, even though he himself was very wealthy, but still borrowed $1 million for his own companies from his mom, and then said later on I would pay the money back. Well, I had him removed, and the $1 million was repaid with surcharge. Okay. A couple cases that you should be aware of. You can do fee shifting in probate matters. There's an older case, which is Dinowitz, which is the fee shifting of guardian ad litem fees in accounting actions. Has been really expanded in the most recent case, which is the estate of Elias, which says that you can surcharge and have attorney's fees against the party that's committing the malfeasance. So in prior years, this was a little bit more difficult. The Dinowitz case was very limited, but it's been expanded, and I have been successful in numerous cases in getting the fees of the guardian ad litem and the litigation and the costs assessed against the guardian to have those fees repaid back in the estate if you have to do a hearing to get them out. If the matter goes on appeal, you want to have the guardian removed during the pendency of it so that there's a temporary in place to go ahead and manage that, because you could be looking at another year. And again, you don't want a guardian who is stealing money during the pendency of the case to have an additional year to deplete the balance of the assets. I did talk about suit on bond. Suit on bond. So now you go, you've removed your guardian. You've done your accounting action. There's judgment against the guardian for $50,000. Your fees are assessed and they're $15,000. And you hopefully you've notified the bond at an earlier stage, but you do suit on bond. That's why we've paid those bonds for the last how many years we've been doing probate here. Because the bonding company there is the agent that is able to make the estate whole again, so that you're not chasing down the guardian individually trying to get $50 a week for the end of time for the $1 million that they stole, and now they file bankruptcy. Just as an aside, a fiduciary can't discharge their fiduciary debts in bankruptcy. There's a provision that does not allow that. So if they file bankruptcy and say, well, I'm just going to file bankruptcy, that's absolutely false. So do not take that bluff that they're going to discharge it. You can write the judgment in a certain way so that it will be protected for purposes of collection forever. Also, again, okay, so you've gotten the guardian removed, you've gotten your judgment, you've filed your suit on bond, the bonding company has gone ahead and repaid the money in the estate, they now have their subrogation suit against the guardian, it's their problem, they go ahead and chase the guardian, and you've had your temporary guardian appointed who's been, during the pendency of this case, has been monitoring and taking care of everything. Now you want your petition for successor guardianship, because now you want new fiduciaries to act. So you're going to try to locate family, you're going to try to locate professional care management agencies who can serve if there's no one, banks to serve if there's a lot of assets here, and if not, then you're going to look to the state guardian's office or the public guardian's office. Okay? And I think that's an hour. Thank you.
Any questions?
Oh, questions. I'll hang around for any questions that you guys might have. No problem.